Alright, so let's continue from what we had left in the last session. In the last session, we had seen the mode of payment of wages and the fixation of the wage period and the time limit of the wage period. In this session, we shall see the deduction part of the concept of payment of wages in the Code on Wages 2019. So section 18 is the section that we have to discuss in this session. Now section 18 talks about the deduction. What it says that a deduction should mean any payment which is being made by an employee to the employer or his agent shall be deemed to be a deduction from the side of an employee. So if an employee is paying anything, any payment which is being made, or which is transferred to the employer or any agent of an employer shall be considered as a deduction. And section 18 states that the wages shall be paid without unauthorized deductions, which mean that there may be some authorized deductions from the wages of the employee. So we are looking at the concept of the payment of wages, and which states that the wages shall be paid without any deduction or without any unauthorized deduction. It states that there can be or there could be some authorized deductions from the wages of the employee, from the side of employer. Further, it says that any loss of wages to an employee for a good or sufficient cause may be resulting from withholding of increment or promotion, reduction to a lower post or time scale, or the suspension shall not be deemed to be a deduction from the wage. So if an employee is, if the employee's increment is being withheld, or maybe it's being withheld for a unlimited time, or any promotion is being withheld for a time being, or maybe for a longer duration, or if in case there is a reduction of the employee to a lower post, if the person is at a particular post and his designation has been reduced or lowered down, or maybe the time scale, if the worker is a daily worker or is being paid on hour basis, or maybe on the basis of the work which is being done by the employee. We have seen in the concept of the minimum wage that there are some workers who are working on the basis of a piece-based worker, right? On the basis of the of the work that they are working, they will be given the wages. So for such workers, if their time or the working hours are reduced, or maybe if in case any worker is being suspended, then such suspension or such reduction of a reduction to a lower post or the time scale, or maybe such reduction or withholding of the increment or the promotion shall not be considered as a deduction, or it should be treated separately than the term deduction, or shall not be considered as deduction if there are any loss of wages due to these reasons. Now then, in that case, what is actually deduction, or what would be considered as an authorized deduction? So section 18 itself provides us a list of deductions that could be considered as a valid deduction from the wages of the employee. Now the first one is from that particular list. Let's see the list first. So the first one is fines. If in case there are any fines for a neglect, or for some work which is, or some misbehavior of the employee from the side of an employer from his wages, such fines will not be considered as a deduction from the wages. So if such fines are imposed by the employer on employee, it won't be considered as deduction, because section 18 says that the wages shall be paid without any unauthorized deductions by the employers to the employee. So in that case, we have to identify what would be considered as a deduction and what would be considered as authorized and unauthorized deduction. So section 18 lists out some authorized deduction. The first one is fine. If in case there is any fine, as I just said, from the side of an employer, which is legit fine, and is fulfilling the provisions. There are further provisions detailing this some of this authorized deductions. So if the such provision is being fulfilled while imposing such fine, it won't be considered as unauthorized deduction, and it is an authorized deduction. And hence if any amount which is being which is being not paid, or which is being what do you call deducted from the wages of the employer as a fine, by way of fine, it won't be considered as an unauthorized deduction. Another is absence from duty. If in case any worker or any employee is absent from the duty, has not reported to the duty workforce, then in that case, for such absence, the wages that has to be paid for that particular day, or for such during such absence, may be withheld or may be deducted from his wages, and it won't be considered as a deduction, or it would be considered as an authorized deduction. So it is not something which is contrary to section 18 of the Code on Wages. Next is any damage or loss of goods or money which is expressly entrusted to the employee for custody or to take account due to his neglect or default. If in case any goods or money is being given to the employee by the employer to take it or to consider to keep it in the custody of such employee and to take care of it, and if the employee has, because of his neglect or default, has lost that, or has lost such goods, or have damaged lose such money, or have damaged such goods, then in that case the amount for such goods or amount of such money may be deducted from the wages of the employee and would be considered as an authorized deduction. Next is house accommodation supplied. See, here now you will be confused that in the definition of a wages we had seen that house accommodation is not something which is a part of a wage, and if such facility is being provided by the employer to the employee, he should not claim that this is a wage of the employee. So this particular section says that if there is any house accommodation which is being supplied, and if there is any deduction for the amount of value of that particular house accommodation, if maybe a rent is being taken by the employer from the employee, or if any a percentage of any value of the rent is being taken by the employer from the employee, it would be considered as an authorized deduction. Why? Now see, this is not contrary to the definition of a wage, because the definition of a wage says that house accommodation or any other such facilities which is being specified by the appropriate government, that it should not form a part of the wages, should not be considered as a part of a wage. That is what is mentioned in the definition of the wage within the Code on Wages. Whereas in this particular section 18 also, it is clearly mentioned that if there is any house accommodation supplied either by the employer or maybe by the appropriate government or the department of the appropriate government, and if it is specifically specified by the appropriate government that the whatever the value of the rent or this house accommodation supply, it has to be deducted from his that means employee's wages, and should be paid to the one to whom that particular house is belonging, then that would be considered as an authorized deduction and not unauthorized deduction. Next is any amenities or services which are being supplied by the employer to the employee, or maybe from the government's appropriate government side is being supplied to the employee. The amount for such amenities or such services could be considered as could be considered as an authorized deduction and will not amount to unauthorized deduction from the wages of the employee. Next is recovery of any advances or adjustment of overpayments of the wages. If in case the employer has paid some advances to the employee, for example, if the employee is in need of money and the employer has considering the request of the employee, has paid some advanced money or something in advance, or if if in case employee has asked, okay, give me 2 months wages in this particular month, and then you may deduct that, one extra month's wages from my next 5 or 6 months wages or remuneration, that could be done. Or if in case sometime, employers do by mistake overpay, the wages, so then in that case the advancement or that overpayment of the wages could be recovered by the employer from the employees or from the wages of the employees, and that will not be considered as a deduction or violation or contravention of section 18. Next is recovery of loans which are made from labor welfare fund. Now again, there are two kinds of the recovery of loans which are specified, so let's see both of them together. Next is recovery of loans which are granted for house building or for other purposes approved by the state government. So either of these loans, when it's being taken by the employee, then in that case the premiums or the amount towards that payment of the loan could be deducted from the wages of the employee itself, as it's being I prescribed or agreed by the employee that okay, you can give me a loan of 5 lakh, and from my wages you can every time you can deduct 25 or 30% of my wages towards this payment of the loan. So that could be done, or that could be justified if such reductions are being made from the wages of the employee by the employer. Next is if any income tax or statutory levy is payable by the employee. If the employee has to pay some income tax or any other levy, right, any other this taxes which has to be paid by the employee towards different bodies created by the government, maybe central or state government, then in that case such income tax or such statutory levy which is being deducted from the wages of the employee will not be considered as an unauthorized deduction. Next is subscriptions to and for repayment of advances from any provident fund, pension fund, health insurance, or any other social security fund. There are different social security funds which are which are offered by the governments or constituted by the government agencies, right? Now if in case from such social security funds like provident fund is there, pension fund is there, if any employee has advanced some money, has taken money from such accumulated fund of that particular employee, then the amount which is being advanced can be repaid or can be recovered by by different deductions which can be made from the employee's wages by the employer, and it won't be considered as unauthorized deduction, and it shall be considered as an authorized deduction. Next is payment of any cooperative society. If in case the employee is a member of any cooperative society, and if there are any payments which needs to be made towards such cooperative society, and if there is an agreement, explicit agreement between employer and employee that for such membership of the cooperative society, the employee will pay such money or the wage, it should be paid from the wages of such employee, employer may deduct such amount from the wages of the employee. Next is this is with written authorization. This section provides with written authorization payment of the fees and contribution of membership of any trade union or to any fund which is specified by the central government. If in case the employee is a part of any any trade union, a registered trade union, and could be an unregistered trade union as well, because this is not explicitly mentioned in the provision. So if the employee is a member of any trade union and has given written given authorization in written to the employer that the amount towards such membership should be deducted from the wages of the employee, it won't be considered as an unauthorized deduction. Next is recovery of any losses sustained by the railway administration on account of acceptance by the employee of a counterfeit or forged currency, or due to failure to invoice, to bill, to collect or account for charges due to railway administration. If in case any employee of a railway administration has has lost any money which he had to take care of, he had to he was accountable to take care of, or to have it was in his custody, and if that is being lost by such employee, then the recovery can be made by the railway department, that railway administration, from the wages of such employee. Now these were the lists of authorized deductions under section 18. Section 18 says that first it says that there cannot be any, or there shall not be any deduction from the wages of the employee. It says that all the wages or all the employees shall be paid wages without any deduction. Then it says that there could be some authorized deductions, or such deductions will not be considered as unauthorized under this particular section. Then after this list of authorized deductions, section 18 says that up to what extent such deductions can be made. Okay, we understood that these would be deductions would be considered as authorized deduction. What should be considered, or up to what extent such deduction can be made, whether the entire wages or entire remuneration of the employee can be taken or can be deducted toward the fulfillment of one or the other criteria or another authorized deduction. So section 18 clause 3 provides that the total amount of deductions in any wage period from the wages of the employee shall not exceed 50% of such wage. So if the employee is withdrawing the salary of, or the remuneration of 20,000 in one particular wage period, the amount of the deduction, authorized deduction, shall not exceed 50%. That means 10,000, beyond 10,000 no deduction can be made from the wages of such employee. So up to 10,000 there could be different deductions which are considered as authorized, but beyond 10,000 no deduction can be made. So this is a very important provision which has been drafted so that the employees will never be never remain without salary or without any remuneration, or will always have at least, or will be paid to continue their livelihood, right? Then further it says that in case, for example, if there are, we have seen different the list of the authorized deductions, and if the employee's deduction is exceeding this 50% of the deduction limit, because the section says that a deduction can be made up to 50% of the wages of any employee. So what if the deduction, the total amount of the deduction is exceeding this 50%? If the employee has to pay maybe 15,000 and his salary is 20,000, then in that case how this 5,000, the excess amount, could be could be recovered. So for that, section says that it could be recovered in a manner which is prescribed by the government. So that means if there are any special manners which are prescribed, maybe that from his bonus or from his gratuity or from any other fund which is being accumulated, it could be recovered. So in that way it can be recovered. Again, it is not specifically or explicitly mentioned how it has to be deducted, or what is the method or mode of such deduction to be made, or such recovery to be made for the excess of the deduction beyond 50%. Other than this, if in case where the deductions are made by the employer from the wages of an employee, but has not deposited to the account of the external such agency, employee will not be held liable for such such non-submission or such default of the employer. Now, for instance, we have seen that house accommodation supply or the deduction towards the house accommodation supplied to the employee will be considered as a justified deduction or authorized deduction. So if in case a government agency has provided house accommodation, and in that case there is a particular amount that has to be paid to such government agency or government department if the employer has deducted the amount from the wages of the employee but has not paid it to such external agency towards that criteria for which it has been deducted from the wages of the employee, then in that case such default of the employer shall have no impact on the employee or shall not be considered as a neglect or liability of the employee, that he has not, or shall not be considered as a default of the employee that he has not paid any wages or any amount towards such required supply. So that in that case, in such cases or in such instances when the employers are deducting the amount from the wages of the employee but is not depositing it in the accounts of such external agencies, it would be considered as a default of the employee. So let's see some of the authorized deductions in detail in the next session. Thank you.